was my VPN that messed me up. I mean, it wasn't on, and then right when I put it on, it starts to work. That's just messed up. I'm gonna have to take this in.
It's a book. It's titled "The People Shall Judge." I'll show it to you. There you go. The People Shall Judge. It's volume number 1. I don't know how many volumes there were. It's 1949 copyright and publication. And it is put out. Let me get to the information here a minute. By the College of the University of Chicago, and it is Readings in the Formation of American Policy. And it has a quote in it from John Locke. You've heard of John Locke?
No.
He was a famous American patriot back in the 1800s, early 1800s, and the quote of him they have in here says, "Who shall be judge, whether the prince or legislative act contrary to their trust? The people shall judge, for who shall be judge, whether the trustee or deputy acts well, and according to the trust reposed in him, but he who deputes him." In other words, who's the best judge but the one who authorizes the deputy? And if that's done by the people, okay, then it's, the people are the best judge. And that's what I've been trying to share with various of our constituents who are out here fighting the same battle you're fighting. And when it comes to correction of status, you have to seize your judgeship in order to gain your legal power. You have to become a judge. And that doesn't
before. I've heard that you have to tell them what to do, basically.
You have to tell them what to do. And the reason why is because in ordering the thems what to do, you are expressing to them your good judgment in business. You're executing good judgment decisions in commerce, and that is a high mark of maturity. And it has to do with maturing the trust. What we all should have known years ago, and none of us did, is that our children and ourselves and everything we have and hold dear should have been enrolled in each of our own private trusts and then buried 16 layers deep, turned invisible to the state of imperfection.
Right. Yeah.
Had we known of this and been able to perfect that, then none of us that we know now would be in this predicament.
Yeah, because they can't touch them.
Yep, you can't know what you don't know until you know about it, and then it's up to you to make a move on it. I've done everything in my power that I can do right now, and the only thing I lack in perfecting the entire thing is 2 forms from the IRS. If I can get those last 2 forms, I will, at that point, I will have access to my trust. I've got to notify the U.S. Treasury of its value. They will accept whatever I put on it. It needs to be, quote unquote, reasonable and equitous. So I think it reasonable and equitous that my revolving trust be worth $500 million. And so I'm going to appraise the United States Treasury of its value. And when I receive back from them their stamp of recognition and approval, at that point, I will have all the forms necessary from the IRS to engage in commerce and begin to discharge obligations of debt via the revolving trust instead of out of my hind end, so to speak.
Okay, so like which forms do you need?
I don't remember right offhand the last 2, but it's like a 1099 C and a 1060 something. I've got the 1099A, which is for the acquisition of abandoned property. There's two ways in there, the word acquisition and the word abandoned. The trust, which formerly was abandoned, I have in fact seized and copyrighted. I am now the sole accessor to it, and no one else has authority to access it unless they make a preferment of a business deal to me. I inspect it at my leisure and grant them recognition, turning their preferment into a durable, a hardened contract.
I see.
If I do that, then we have a durable contract wherein both of us can be held liable for breach of fiduciary trust should harm result from misuse of the properties within the trust.
That will be after it's set up though, right?
That's correct.
So we
Yep,
can't
that's
retro it.
Well, I have it set up. I do have the trust established, and I am on board as the judge, the trustee, and the doing of it, the simple doing of it, automatically brings along with it quasi-judicial immunity because everything you're doing is being done in the legal realm of commerce.
I
So
see.
quasi-judicial immunity is an automatic that is afforded right away to the new trustee, to the actual trustee. See, that's the problem. People all over the internet are jumping up and down, clamoring for quasi-judicial or total immunity to be completely done away with. Well, that's a lack of research and study and information. Don't do away with it. Take it out of the wrong hands and get it in the right ones.
Yeah.
The birth certificate is a death certificate at the end of 6 months. The first 6 months, it rolls over, it flips upside down and turns into a death certificate. But it is not something that needs to be feared. It is actually a tool, a banking document that you're going to need.
So this certificate of death, now when does that, because you get a certificate of live birth right when they're born, and then you
Right.
apply for the birth certificate.
Exactly. And it's the birth certificate that at the end of the infant's 6 months, the first 6 months of life, if the status of the infant has not been corrected, it automatically reverts to a death certificate and announces a legal death.
So if no one applies for this birth certificate, then it should turn over to a death certificate.
Yes, and if there be no trustee over the estate, now that it's a death certificate, then the estate is wide open for plundering, the grave is wide open, and whatever is in it can just be removed because there is no trustee. Nobody is standing watch.
Got it.
Okay, and
I
that's
found
what
out that paperwork of that one guy that I told you that was with the association. I found it all. And what did I do with it? We might be able to use some of this stuff here. It's related to the IRS, about paying taxes, but I think we can use it for.
Well, see, the thing is that, the IRS is in a real pinch.
Yeah.
They have to prove their claim. And their claim is everybody's a federal citizen. But the problem for them is that claim is made based on an assumption that nobody is going to say, oh, really? Title 26, Section 18 says otherwise. And it's your code. You guys wrote it.
Right. So what?
But I did. I rose to the challenge. When they made that claim against my trust in 2013, I didn't have this knowledge then yet, so I'm speaking for then as now. When they rose to plunder the trust in 2013, I did not grant them access. Instead, I said, "Not so quick, boys. This is commercial poker.
Yeah.
You're hedging a bet. So I see your claim and I raise you one challenge. Show forth the durable evidence that cannot be breached that in fact I am a federal citizen as you have claimed.
Right?
Have, take your time. You got 30 days and then we'll proceed. Well, 2 weeks later, I got notice from the Mensis Bank that impersonates as if it were a federal court that the estate disbursement proceedings were going to occur. And that told me instantly upon receipt of that letter that the IRS could not meet the challenge to their claim.
I see.
And then what
blow it
really
out of the
red
water.
flag, what really gave me a red flag on the deal was the court went out of its way to make it plain that my presence was not required in any way, shape, or form.
Oh, really?
And I'm like, how come they're going so far out of their way to make wide open the door for me not to be there? I now need to be there. So I
Oh, yeah.
physically went and I got my stuff right on and in the federal record. And when I was done, it took a total of 18 minutes. The IRS went into default because they couldn't back their claim. The attorney on their behalf refused to speak in the court. The federal judge, Holly Brown and Bozeman, since retired, yelled at their attorney 3 times to get him to speak. And on the 3rd time of her physically yelling at him in the courtroom, stood to her feet and yelled at him to get him out of his reverie. When he did address the court, he was so scared he could hardly speak. He stuttered like a kid in school. It was pretty sad. He's about 70
I
years
love
of
it.
age.
I fucking love it.
And then when she signed off on my win, she wept that day. She openly wept in the court and
Really?
told me later, nobody has ever done what you have done. She said, I've never heard of it in my entire career, but you have shown something that this court had no idea about. And today I have become your student.
Whoa. Wow.
Following year, the state rose against me and I went right back in. I filed suit in tort, municipal, county, state, and federal, because I know they're embroiled as if one due to the merging of jurisdictions, 1851. So I filed it in all 4 venues, 3, but 4, and sat back to see what was going to happen. the same night that I filed it in, Holly Brown, the federal administrator, went in after hours and erased the entire thing.
The one that wept on the stand?
Yes.
She erased the entire thing.
She erased my entire suit, my entire case, the whole thing, as
But
if
why?
I never filed any. Fear. She saw a locomotive coming in sideways that was going to go the entire length of her legal career and destroy her legal career.
Destroy her because of her ruling. Because of her ruling, previous ruling.
She's the one who is going to have to be on the stand and referee that fight through. And she already was aware of my capability with this sort of thing, and she wanted nothing to do with it.
Holy
so she
moly.
it all as if it never was filed.
Did she admit that, or how'd you find that out?
I went in the next day to check on the status of my filed in case, and the secretary had a bright red flaming face and said, oh, God, there's no record of any case having been filed in. And I said, isn't that funny? I talked to you yesterday and used you to file it in through. I have
she filed it, huh? And then she was like, where is it? Yeah, so wow.
So everything backed off of me and I let it go.
You let it go. Yeah.
I guess I'd already proven my point.
Yeah. Now, okay, so this paperwork that I have here is from this guy. It's an affidavit for a demand affidavit, denial of jurisdiction, rejection of the tax lien, sovereign in his property. And then he goes on to talk about, here's a statement of facts that the proof that the government is a corporation. But you've already gone through all that with your courts and stuff, but I thought it was kind of interesting. It says, As it has been stated before, Clark County and Washington State are privately held corporations. Therefore, they are not constitutional in nature. A constitutional and a corporate governance are mutually exclusive. No one can be in power at a time. No one can be in power at a time. The corporations were put into place unconstitutionally. Therefore, the corporations have to lie and commit fraud on the people to keep themselves in unlawful power. The main problem of the corporate government is that it must support the constitutions that it swears an oath to support. So the main problem of the corporate government is that it must support the constitutions that it swears on oath to support. I don't know if that's a true statement, but the corporate government has a big problem to be legal. Since they are not constitutional in nature, they are corporations and private in nature. Therefore, since they are private in nature, the corporations must have contracts with all the sovereigns of the state and the country before they can have jurisdiction over them and treat them as corporate slaves.
That's correct.
They have to have a contract with us. Clark County must prove that they have private jurisdiction over the sovereign individual before the corporation can remove constitutional rights that are guaranteed pursuant to the 1787 Constitution of the United States of America and the 1878 Constitution of the State of Washington. Eminent domain, Article 2, Section 3, which is, quote, the people of the state in their right of sovereignty are declared to possess the ultimate property in and all lands within the jurisdiction of the state, and all lands, the title to which shall fail from a defect of heirs shall revert or escheat, I guess that's how you say it, to the state.
How's it spelled?
E-S.
Oh yeah, the yep.
Escheat.
Yep.
So they're basically saying that the people of the state are declared the people of the state are declared to possess the ultimate property in and to all lands within the jurisdiction of the state, and all lands, the title to which shall fail from a defect of heirs shall revert or escheat to the state. It says Clark County does not have a wet ink signature contract to demand any type of jurisdiction over David A. Darby. All above, that's the guy who wrote this. All of the above has been proven in the unrebuttable criminal complaint affidavit. Therefore, in the eyes of the law, it now stands as the truth.
Yes.
In the corporation, anyone that does not know his rights will be considered a corporate citizen unless the sovereign officially denies the corporation's jurisdiction. This is where the phrase ignorance of the law is no excuse. In this case, the Clark County treasurer is acting as if he is ignorant of the law of the Constitution, or that they are pretending ignorance to be able to commit the fraud on the sovereign.
Yes.
All right.
Did you get the piece I sent you on fraud this morning?
Yeah, I did. Let's review it for a second. Let me make sure I'm looking at the right one here. Yeah, the fraud that they have to be. I couldn't read the small script of it.
Yes.
What she wrote, but I understood what she was saying.
Well, I wrote it out by hand, real nice.
Out of fraud, no action arises. When the foundation is wrong, all is wrong.
That's it.
When the foundation is wrong, it's all wrong.
Yep. And so now let's jump it to the article on the piracy that I sent you this morning, and reminded you that though that information on the piracy and the punitives applicable to acts of piracy, though on its face it seems valid and usable in the crap we're battling, one has to remember that in 1851, via the merging and blending of the jurisdictions separately enumerated in Article 3, they have reversed piracy.
Okay.
So the core pirates, when I say corporate, I drop the O and put in an I. The core pirates are on the land. They're not out to sea. They're on the land. They cross the bar, but that bar is what is called the sandbar. So they cross the sandbar, which is also referred to as the beach, and there they take command of their vessel, judicially speaking, legislatively speaking, and they ship out to sea to commit acts of piracy upon the high sea.
Right.
Well, the high sea, the sea that they're directly referencing indirectly, is the three C's of the CSTKV Trust, 1541, 1666, and 1871.
Okay.
That's the high seas. So that, was it you? I've had quite a few good conversations going today. Was it you that I said that those who do these acts of piracy without license to engage in commerce, they don't have a valid license to do business with and in the state of Washington, a known corporation, are actually robbing the Bank of Rome.
Oh,
They're robbing the Vatican Bank.
I see.